Good afternoon. Call the case People versus Hull. This is a 20-minute argument per side. It's a mini oral argument on the application. And do we know the division of time? Okay, and you'll let me know when. Okay, great.
Good afternoon, Your Honors, and may it please the Court. Mike Waldo from the State Appellate Defender Office on behalf of Brandi Hall. I'm joined at counsel table by co-counsel Allie Wright, as well as counsel for Anthony Hall, Alona Sharon. Ms. Sharon and I will be sharing our time this afternoon, and we request to reserve 3 minutes for rebuttal, please. In People v. Moreno, this Court recognized that the common law right to resist an unlawful arrest remains in Michigan. The resisting and obstructing statute at issue in this case specifies that the prosecution must establish not only that an arrestee resisted or obstructed the arrest, but that the arrestee knows or has reason to know that the arresting officer was performing his or her duties at the time of the arrest. In other words, if the arrestee has reasonable doubt that the officer is performing his or her duties at the time of the arrest, then the crime is not established. First and foremost, to be clear, the evidence was insufficient to convict Brandi Hall of resisting and obstructing because she did not resist. I know that Your Honors have had a chance to review the video that was submitted with our pleadings, and the video, I think, speaks for itself, so I won't try to rehash all of that here during my introduction. But when Chief Pearsall arrives, Brandi does what she's allowed to do. She asks questions. She tries to clarify. Things happen. She's ultimately forced inside the home, and they do what I think we would expect citizens to do. They call the police to clarify the misinformation that they were told. Like the defendant in Moreno, Brandi, even if this court concludes that a reasonable juror could have concluded that the prosecution established that Brandi resisted, like the defendant in Moreno, Brandi had a right to do so based on the misinformation provided by Chief Pearsall. And that's for all the information, all the reasons that we stated in the brief. She's a woman, answers the knock at her door at 8 o'clock at night. She's confronted with Chief Pearsall as well as an unidentified gentleman in street clothes who she believes to be, I understand he was a ride-along, but she believes to be the chief's friend. And the chief proceeds to tell her that he's arresting her for a warrant based on excessive noise exhaust, something that Brandi knows never happened. She had never been pulled over for such an infraction, never had a citation for a loud exhaust, and knew that this warrant didn't exist, and she was right.
Counsel, I have a question.
Yes, sir.
And good afternoon and welcome.
Thank you.
My concern about this is that if the court were to side with your position, would this lead to kind of a little bit of a, wouldn't this create a little bit of an anarchical situation where, you know, you set a precedent or a guidance that allows for people to resist arrest? Could this lead to a chaotic circumstance?
I don't think so, Your Honor. I think that the context here matters. I think it's distinguishable. For example, if an officer were to arrive on my doorstep and tell me that there's a warrant for my arrest for murder that happened in Monroe County 2 weeks ago, I know that that didn't happen, but that doesn't give me a right to resist, because this, I know, I have no reason to doubt that the warrant exists. In this case, and I think this is a very narrow case, Brandi knew that this warrant couldn't exist. This isn't the type of thing that people are arrested for on warrants, Your Honor. This isn't something like a murder warrant, right?
I understand that it was 18 months. I mean, it is a little unique because it was 18 months that had passed. And the question here is that there was, in fact, a warrant. It was for suspended driving, a suspended license, right?
That's right, Your Honor.
Okay, but there was an actual warrant.
Certainly.
It was just quoted to them in the wrong way.
In the wrong way, for the wrong offense, an offense that is not the type of offense in which warrants are issued. I think perhaps there's a legal mechanism for a warrant to be issued for a failure to appear on a civil infraction, but certainly I think most people understand that those aren't the kind of things. Certainly today, after the legislation that was passed, after the jail reform task force, I think this is even more unlikely to happen now. But Brandi, she knew she'd never even been stopped, and that's what she did. That's what she told Chief Pearsall, and I think that's what's a real issue.
How's that any different from the example you just gave about there's a warrant for arrest for murder, and you're like, I've never set foot in Monroe County, can't be me. What's the difference between the two?
Because this is verifiable. Maybe I was wrongly identified by a witness who said, I know him, that's Mike Waldo who did that. And I know, and I think my fellow citizens know, that people are arrested on murder charges. These are serious things, warrants are issued, and you have to go handle that. This is a traffic ticket, something that could just so simply be verified and looked up in the system. And Brandi knows, and she's right, she knows there's no warrant, because there couldn't be a warrant, because not only has she never been cited, she'd never been pulled over for a loud exhaust.
So which one should be litigated on the porch and which one should be litigated in court? Where do we draw the line exactly? Because somebody could have called her or misidentified her as the person making too much noise too, right? So which ones do we have litigated on the porch?
It's a reasonableness test, Your Honor, that we are proposing, that where an officer's actions cause an individual to reasonably believe that the arrest is unlawful, he or she has a right in that circumstance to resist what he or she believes objectively believes is an unlawful
So if the
arrest.
person doesn't think that the warrant's valid for some reasons, they can resist? But if they don't think the warrant's valid for other reasons, they can't resist?
I think it depends on the reasons, Your Honor, and I think it's always a very fact-intensive inquiry, and I think it's a totality of the circumstances test. And all of these details, the context matters. This is a woman told at 8 o'clock at night by a gentleman that she did testify she recognized as the police chief in
She knows
town.
the police officer in his uniform in a marked vehicle, and this is a very unusual case. She knows who he is, and he's the chief, right?
And he's there, yes, Your Honor. He's there with his friend, which she believes is a friend, completely unidentified. The first thing that Brandi Hall
What's that
sees,
have to do with anything?
it goes to the reasonableness of her belief that everything internally inside her in that moment is telling her something is wrong. Who's this stranger who nobody's saying anything about? Unidentified adult
So
male.
you're telling me if you get arrested for a murder you didn't commit in a county you've never been to, everything inside of you is going to be saying, yeah, let's go, I'll go with you and we can work this out later. You're not going to be like, that's not me, I'm not the guy. It seems to me you'd be even more likely to do it for more serious charges than you would for less serious ones, but.
I think I would have some questions, Your Honor, but I would ultimately know, and that's what Brandi does here. I mean, I noted in my introduction that I think the video speaks for itself, and what Brandi does is what I think anybody would do in this scenario. She asks questions. She tries to verify what's going on.
What about the second part of that, though? And Judge Shapiro highlighted this. What about the second encounter, right? I don't believe we have a video of that, but the court of Judge Shapiro found that she didn't have cause and that she did physically resist or obstruct for that second encounter.
Right, Your Honor. There is no video for the second encounter. I don't know that Judge Shapiro found that there was physical resistance
He
or
said
obstruction.
that her actions following the police's return to the house were sufficient for a jury to convict.
Right, I know that's what I said. Right, the point I was trying to make is I'm not sure that he specifically said that they could have concluded that she physically resisted in that second encounter. I certainly disagree with Judge Shapiro, Your Honor. I think the only place, there is no video, the only place where we can really get some discussion in the record about that is from the state trooper, the gentleman who came and sort of cleared everything up, Trooper Reynolds, who testified that he and Chief Pearsall sort of effected that arrest the second time, that there was no resisting and obstruction. Chief Pearsall did say on cross-examination, it was never produced in the people's case in chief, but on cross-examination testified, yes, she did resist and obstruct. But I don't know that Chief Pearsall has quite, respectfully, a keen understanding of what Brandi was allowed to do. Her verbal protestation, which I concede the testimony is that she continued to verbally disagree with what was happening, but that's not sufficient resistance. They said, and I think, in one of the opinions, the majority or otherwise said that they almost had to carry Brandi to the squad car. If they did, I think that would have been resistance, but they didn't. They almost had to. She continued to verbally protest. You know, when an officer is trying to accomplish this arrest, the arrestee, I think, gets to ask questions, and the officer gets to answer those questions, and civil discourse happens. Brandi's voicing her objections is not resisting and obstructing, so I respectfully disagree with Judge Shapiro on that point.
So your contention is that there isn't the necessary physical conduct to constitute the resisting?
Yes, I
Or
think
the
also,
lawful
Your Honor.
command issue?
I'm sorry?
I mean, is that your focus, that she had every right to do that? I mean, don't you agree with me on the lawful command that, yes, she has a right to resist an unlawful command, but she bears the risk that she's wrong, right? Or is later determined to be wrong. And the officers bear the risk that they're wrong as well, that their command was lawful, right? I mean, so, but doesn't, your contention is that there isn't sufficient conduct to constitute the resisting and obstructing part of it? It wasn't
That's right,
sufficiently
Your Honor.
physical?
I don't think that the prosecution has identified a singular act, even in a failure to obey a lawful command that Brandi committed, that justifies conviction under this statute.
I don't want to stop you, but how are you splitting up your time?
Right about now, Your Honor, would be a good time. If I may yield to Ms. Schramm. Thank you, Your Honor.
Thank you for that polite nudge, Justice Sarah. Good afternoon, Your Honors. Alona Sharon on behalf of the other appellant, Anthony Hall. I do just want to address Justice Bernstein, the question and concern about wouldn't this allow for a chaotic circumstance. And I think that something that I would ask, and I think my co-counsel would ask, is for the court to be mindful that the chaos, if you want to call it that, in this particular circumstance, I would say respectfully, arises out of this chief's conduct, right? And I think it's important for the court to remember that the chief testified in his gut. He knew something was wrong here. He knew there was something wrong, that there was a warrant for loud exhaust. It didn't make sense to him. He knew it was something that there typically wouldn't be a warrant for. And despite the fact that everything in his years of experience told him that something is amiss here, he still felt it was necessary to go to the Hull home at 8 o'clock at night and place this woman under arrest for a warrant that he had never personally seen, okay, even though something told him something was afoul or amiss. And what I think is important to remember is that this circumstance, or the potential for chaos, right, could have been entirely avoided if perhaps Chief Pearsall could have been slightly more meticulous in his police work. And I think that that's really the point that the Hulls and that my co-counsel and I are trying to make, is that we're asking the court to look at the officer's conduct, right? If an officer conducts himself or herself in such a way that would give rise to a defendant to have a reasonable belief, right, that the officer isn't in the performance of his duty, does that allow the defendant to resist?
Was there, you're sort of conflating two things. Was there misconduct here by the officer?
I'm not saying that there's misconduct. I'm saying that
Because officers, like other human beings, make mistakes all the time, right?
I'm sorry?
Officers, like other human beings, make mistakes, right?
I understand that. I'm human, we all make mistakes, or maybe I'd argue I made some mistakes this morning, but.
Actually, you're
Me
doing
too.
excellent. You're doing,
Yeah.
you know
No,
what?
that's okay. Look, there's no ego here.
Counsel, I have to say, you're excellent. You do
Thank you, Justice.
you are an outstanding
See,
man.
he's never said that about me. So
Don't take it personally. But, and it's not an issue of, well, do people make mistakes, right? But police officers are entrusted, and they have this awesome responsibility of going to someone's home, depriving them of their liberty, taking them from the confines and safety of their home.
very, very dangerous undertaking we asked them to do on behalf of all of the citizens in the
one
community,
would,
right?
And one would think that in undertaking that responsibility, they would, number one, understand the fear that's instilled in citizens when that happens, and they would undertake special care and concern to make sure that they're doing it with the proper authority. Now, of course, I don't for 1 minute, suggest that.
He had proper authority.
I
He
was
described the warrant.
You read my mind. I
Yeah,
would
I
never
don't-
suggest that there wasn't a valid warrant. No one can test that there was a valid warrant. But I think that this court and officers
There
need
was
to.
some issue with the lien entry. Is that where this comes from? There's
Yeah,
the
so-
way it was coded into lien?
Apparently, when, I think it's the driving while license suspended, or maybe the insurance is entered into the computer for some reason that no one can explain, it comes up as loud exhaust. And for that reason, it led to this entire confusion. But what also led to the confusion was the fact that this officer went out to place a citizen under arrest without ever looking at the warrant. And had he actually looked at that.
He doesn't have to look at the warrant, does he?
There is nothing that requires that he looks at the warrant.
He doesn't have to present the warrant to the person?
100% you are correct.
So
But
your argument is because he didn't follow what you consider to be best practices, your client had a right to resist the arrest?
no, the argument is that his conduct and the factually incorrect information given to Ms. Hull, which was then relayed to my client, Mr. Hull, right, gave them a reasonable belief, because everything that they believed was correct, that there was no warrant for a loud exhaust, right, and he gave them factually incorrect information, led them to reasonably believe that he was not in the performance of his duty. I mean, duty has a legally significant definition. And they reasonably believe that he was not in the performance of his duty. And that arises solely out of his conduct. And that is the question, right, that this court is asking. Can the officer conduct himself in such a way that would give rise to a defendant's ability to resist?
So if the lien operator, the person who, the clerk who entered that information makes a mistake, then the defendant can resist the police officer who just shows up trying to arrest the person, do what we ask them to do. They can expect to be physically resisted because the clerk, a coding error by the clerk.
So
Is that how the system should work?
I think that also there has to be some sensitivity to the level of resistance. Because, and I think Mr. Waldo makes an excellent point of exactly what happened in this case, right? Mr. Hull is concerned about this officer and completely unidentified other person who wants to take his wife away. And what does he do? He doesn't strike the officer. He doesn't come in any physical contact with the officer. He directs his wife back into the house. And the undisputed record is all they do is call the police. Immediately after going back in the house, they call 911.
I thought he closed the door on the officer's foot. Did I pick that up on my own? He slammed it a few times until the officer put his foot in the door to keep it open because he's trying to arrest the person?
So I would suggest that what the video shows is that Mr. Hull goes to close the door to his home, and at that point, Chief Pearsall makes his own decision to put his foot in the doorway.
Right, because he's there to apprehend somebody, and now that person is being whisked away, according to the defense theory, by another person.
And I would suggest to the court that the level of, if you want to call it.
Which, by the way, then creates a much more dangerous situation because now they're behind closed doors and he has no idea what these two individuals are doing, right? They could be retrieving firearms. They could be doing all sorts of things that could make the situation far more dangerous for the officer, right?
Well, it's certainly dangerous to the extent that the chief threatened to shoot Mr. Hull at that point, but
That's the only reason it's dangerous? You don't think there's any danger presented to police officers?
there wasn't danger presented by Mr. Hull and his wife. They simply wanted to contact 911 to
But
confirm.
once they close the door, don't you see how the danger level goes up astronomically? That's why he doesn't want them to close the door?
I don't disagree that there is a myriad of hypotheticals that the court can imagine and that we can imagine.
You don't have to imagine them. You can read the newspaper when police officers go out to somebody's house on a domestic case and they approach the house and they're shot from somebody in the house and they die. So you don't have to imagine it. You just have to read the newspaper.
Just like the court can read in the newspaper about people who impersonate officers and try to victimize women.
So should we litigate every warrant on the porch, or should we litigate them in the courtroom?
No, what the court should consider is what is reasonable behavior on the part of a defendant. And for Ms. Hull, who is a woman, out in the dark of night, when you look at that video,
He
confronted,
knows he's the police chief. I mean, does that
who
carry
is
no?
accompanied by an unidentified male for something that she knows didn't happen, that is factually incorrect, and respectfully, and I mean this, maybe as a man, it's not something that can be appreciated.
I wouldn't want to be arrested either. I'm sure it's not a pleasant
It's
thing for any
different,
person.
respectfully, for a woman being confronted by two men, and the first person she encounters isn't the chief. It's the man in plain
So
clothing.
should we have women arrest women? Is that what you're suggesting?
I think Your Honor is taking it a bit lightly. And the
I'm not,
fact,
I'm asking you, would it be different if a woman was the arresting officer? Is that what you're
No.
suggesting?
what I think the court needs to be sensitive to is the fact that when a defendant is given factually incorrect information about why they are being placed under arrest, and that person knows it is incorrect to the point where they can reasonably question if the officer is performing his duty, then that person has a right to resist.
So is there a, excuse me, is there a line between the situation here where your client's wife knew that what was being presented, like that did not happen? There's nothing out there. But what if it was factually inaccurate, but it possibly could have been true, or they don't know that there's a warrant out in relation to something else? Can an individual where there's a warrant, if they're not aware of it, they have no reason to think that it's accurate, they can resist?
So I think it's always just going to, and I think Mr. Waldo made the point correctly, it's going to be a question of reasonableness, and what exactly are we talking about resisting, right? Is the person just going to ask questions and say, can I call the police and try and verify this? I think it's always going to be a question of reasonableness. And again, we're always looking, what we're asking is to always look at the conduct of the officer. And I do think whatever holding comes out of this court, it is a very narrow set of facts in this court. I think
Did your client or your client's wife know that there was a warrant for driving while license suspended?
No, and I think the testimony is clear from that they were both under a firm belief that she had dealt with that, they had paid the tickets.
What if they knew that was outstanding? What if they knew that was out there?
That she, in fact, had a warrant but for something else? I certainly think that would weaken their position.
I actually just want to follow up on that. What about, let's just assume they weren't given the inaccurate information in the first place. It was just the warrant for driving while license suspended. She obviously, I have no doubt, based to doubt what you're saying, that she didn't realize that was still out there. Was she entitled to resist then? I mean, it's a valid warrant, right?
Right. And I think at that point, Your Honor, it would perhaps be more at her own risk. I'm a little bit uncomfortable addressing questions related to Ms. Hull just because she's not my client.
Right, fair enough, yes.
So I don't want to speak out of turn because I'm
Yeah.
not her advocate.
Yeah.
But if the court has no other questions, and I see we have no time for rebuttal, Mr. Waldo. Thank you very much.
Thank you.
Good afternoon. May it please the court, Assistant Attorney General Brent Morton on behalf of Tuscola County. This court in People versus Marino clarified that an individual has a right to resist unlawful conduct. In this case, the Hall's resistance and obstruction is not excusable because the arrest because the arrest warrant was valid and the actions of Chief Parcell were lawful. In fact, Chief Parcell made the point to verify with dispatch that it was a valid warrant. The Halls argue for this court to expand the holding in Marino and transform this objective test of lawfulness to a subjective test based on the perception of the individual being arrested. Such a change is not consistent with Marino, does not follow the common law, and would not be beneficial for change in Michigan's jurisprudence. The purpose of the resisting and obstructing statute is to protect law enforcement officers from physical harm. Under Marino, that protection only exists when the officer is operating within the law, and an officer who is pursuing unlawful acts is not protected. To properly deter unlawful police conduct, the determination of the lawfulness of the conduct must remain objective. A subjective test, as advocated by the Halls, would not encourage the officers to make sure that their conduct is lawful, but instead would focus their concern on how much information they're willing to communicate to the person who's being arrested for fear that they may make an insignificant misstatement, as in this case. The arrest warrant that Chief Purcell was executing was valid. It was verified by dispatch, and it was a result of Brandi not appearing for a DWS arraignment. She had received notification, which is in the Court of Appeals opinion, recitation of the facts. She received notification from the court to appear. She called the court and said, it's all taken care of. She never appeared. A trial court issued a bench warrant.
Counsel, good morning, or I apologize, afternoon.
Yes, Justice Bernstein, good morning.
First, it's always a pleasure to have you here. I just have a few questions just to kind of get to the root of this. And first off, there's a lot of unusuality in this that is hard to follow. What was the urgency of this? It's 18 months to go to someone's house at 8 o'clock at night. It's a little unusual, isn't it?
Well, I think I don't know if there was any urgency in this. I think Chief Purcell was asked to execute this warrant and arrest Brandi, and he went and did that. I think that probably the delay was the case was issued, it was set for the court, she failed to appear at court, a warrant was issued, and then it came time to execute it. But I don't think there's any urgency here. But I do agree with you, Justice Bernstein, this is an incredibly rare and unique case. And that's why you should deny this application. It's not a good case. It's a unique set of facts in which to base statewide law and impact our jurisprudence for all arrests on the doorstep. Furthermore, the reliance by this court on Drennan is not proper. Drennan's case was a case about assault with intent to murder. And so there's a lot of discussion about the perceptions of John Drennan and what he believed was occurring. But that's in the context of determining his intent for the assault and whether or not he committed intent with the assault to murder.
Can you explain to me, so the statute obviously requires the use or threatened use of physical interference or force. And what's described, at least in the second encounter, is that Brandi almost had to be picked up and carried to the car. Not that she had to be picked up, not that she was sort of pushed to the car or whatever. I mean, I could envision where, you know, there is some physicality described, but we don't have a video of it, and all we have is a description of almost had to be picked up and carried. How is that the use or threatened use of physical interference or force?
Well,
physical interference. I mean, she almost had to be picked up. So she's just standing there and very strongly, maybe even obnoxiously, whatever it may be, asserting, you know, verbally asserting that this is wrong and that that this shouldn't be happening, and, you know, all of that. But she's not physically resisting, but she almost had to be. Is that sufficient under Moreno?
Well, Your Honor, I believe Brandi's conviction's based on her initial interaction and her delaying of the arrest.
Okay, well, let's say I'm sort of going to, because I think for Brandi to succeed, she needs to show that neither encounter, you know, I sort of view them as two encounters, at the steps, if that is only verbal resistance, but the second encounter where she almost had to be picked up and carried to the patrol car, that's closer, but why is it actually all the way there as opposed to just almost all the way there?
Well, my position is it is all the way there. It's obstructing the arrest. It's interfering with the officer. However, and I do have a note here, I don't believe that the second encounter is relevant because if you go back in the transcripts to the fourth transcript, page 172, she was only charged with resisting and obstructing Chief Purcell. And I believe there's been some mistake in the lower court with regard to that record. I apologize, I was not the attorney at that time. But my reading of the record is she was charged with resisting, obstructing Chief Purcell. She delayed the arrest, and then later when she testified at trial, she said, even if he told me the right thing, I would have told him not to arrest me, and we would have got the receipts and told him it was all
So,
set.
but doesn't the definition, the statutorily defined definition of obstruct is the use or threatened use of physical interference or force, or a knowing failure to comply?
Well, but you also have resistance, you have opposing. She opposed the arrest by not complying, by not cooperating. So there's several terms that can be included in that.
Okay.
Thank you. Also, there's been some disagreement between Mr. Waldo and myself regarding whether or not there's still a duty to inform someone of the arrest. I think that's been modified by statute. If you compare MCL 764.18 and 764.19, you can see if you're executing an arrest without a warrant, the officer is required to demonstrate or communicate his authority and the cause of the arrest, or the reason for the arrest. However, if you have a valid arrest warrant, you only have to inform the person that there's a warrant for the arrest. You don't have to inform them of the reason for it. And so, our position is that Chief Purcell at the time should have said, I have a warrant for your arrest, and not really gone into any discussion about what the purpose was. And I think if you adopt a subjective test to determining lawfulness of the police conduct, then I believe that that's what will happen. Law enforcement will be trained. You don't tell them anything. You tell them you have a valid arrest warrant. You don't have an interaction. You don't try to get voluntary cooperation, because any misstatement you made, no matter how innocent, could cause that person to be able to argue with you and cause harm to you. Furthermore, with regard to the third-party ability to resist, you can assist someone in resistance, but you're taking on the same risk. Whether or not the activity is lawful is going to determine whether or not you could join in the resistance. And so if you believe someone that's telling them, well, this isn't a valid warrant, then you're going to resist or assist the resistance to your own peril, depending on whether or not the conduct was lawful. As I indicated before, I think this is an incredibly unique case. I don't think it's the sort of case that this court should be making law on, and I'm happy to answer any other questions.
Any other questions? I don't see any.
Thank you very much.
Your time is up. So the case will be submitted. Thank you both.